The next is rights of a minor partner. First, to share the profits and property of the firm. This is very basic. All the partners have a right to share the profits of the firm. All the partners are the joint owners of the firm property. So, he gets a right to share the profits and the property of the firm. Next, to inspect the books of accounts. Now, it is the right of every partner to inspect the books of accounts. Every partner has the right to inspect the books. Since minor is also a partner, he can also inspect the book. He can see if the other partners are giving him a right share. Are the other partners committing some mistakes or frauds or anything of that sort? Though he possibly might not be in a position to find out, yet the law has given him the right to inspect the book. It is not necessary that he should personally inspect. He might get it inspected from anybody else, from a chartered accountant, from his father, or any person. And finally, to file a suit for his share in the firm. However, only when he decides to sever his connection with the firm. He can also file a suit against the firm for his share. But it is important that before filing the suit, he has cut. What do you mean by sever? It means to cut. This is the spelling. So he has to cut the connection with the firm. So he'll have to retire as a partner from the firm. He'll have to exit from the firm first and then file a suit for his share. Okay. Now, what are his liabilities? I told you, as far as liabilities are concerned, he does not have any. However, if the firm is getting wound up or there are a lot of losses to the firm, so whatever profits that have accrued to him, that can be taken from him. See, it is not that minor in no way is liable. Nothing of minor is liable. No, he is not personally liable. He cannot bring in his own assets and pay for firm's debt. No. Whatever profits have accrued to him, only that portion of profits can be liable for firm's losses. So he is not personally liable. He is never personally liable to third parties. Third parties cannot come to the minor partner and ask for dues. No, that is not allowed in the law. Only his share of profit and property is allowed. He will never be personally liable. This is very similar to what we had done in Contract Act. In Contract Act, we said the estate of the minor is liable for necessaries supplied to him. However, he is not personally liable. His estate was liable there, his property was liable there. However, he wasn't liable in his personal capacity. In same terms, his profit and property as a partner in the firm is liable. Whatever property he holds in the firm, whatever profits he has earned from the firm are liable. He will not be personally liable here. He will not bring in his personal assets. No, not possible. Now, minor cannot be declared insolvent. We all know this because minor cannot contract liabilities, and insolvent person is a person whose liabilities are more than the assets. Now we are talking about minor who cannot at first place contract liabilities. So there is no question of minor becoming insolvent. It is not possible. It is unconceivable. Minor cannot be declared or adjudged insolvent. However, if the firm in which this minor is a partner is declared insolvent, then minor will not have any personal liability. On the contrary, whatever property he has in the firm, whatever share he has in the firm, he will come into the category of the creditors towards the firm. Whatever creditors are there, whatever rights they have over the firm. Because what happens is when the firm is insolvent, the court appoints an official liquidator or an official assignee, and this person sells off the assets of the firm and pays off the liabilities. So the creditors stand up before the official assignee or the liquidator. Okay, so minor also gets the same ranking. Minor also gets into the same position of the creditors for his share of property or profits in the firm. So now he gets into the shoes of creditors.